Good morning. Today we will be discussing statements made during psychotherapy. I'm going to start with the federal privilege that exists between psychotherapists and their patients and how that privilege was established. First, why do we need a psychotherapist-patient privilege? Generally, federal privilege rules exclude evidence to further a policy interest outside the courtroom. We need privileges to protect certain relationships that benefit society. For a privilege to be found, the relationship should be one that society wants to foster and one for which confidential communications are essential. The psychotherapist-patient privilege clearly fits these criteria. Psychotherapy benefits society as a whole through the promotion of mental health. Psychotherapy also depends on honest communication and the complete disclosure of facts, emotions, and thoughts. It is even less dependent on physical examination and objective tests than medical treatment, making open communication even more critical than between a doctor and patient. Without the ability to communicate confidentially, patients may withhold information from their therapists, impacting treatment. When the advisory committee first proposed the privilege rule, now Rule 501, to Congress, it contained a list of enumerated privileges, including a detailed psychotherapist-patient privilege. The text on this slide comes from the originally proposed Rule 504, specifically creating the privilege. However, many of these privileges were controversial, and Congress ended up removing the list in favor of broadly opening to common law and allowing federal courts to recognize privileges. Congress substituted a single rule, Rule 501, which directed federal courts to recognize privileges by a common law process. However, the legislative notes indicate that Congress did not intend to indicate disapproval of a psychotherapist-patient privilege by removing the specific rule. Instead, it just opted to defer to state law in a substantive area like privilege. The federal psychotherapist-patient privilege generally protects all confidential communications between a patient and a licensed psychologist, psychiatrist, or social worker. Social workers are often a more affordable option for low-income patients. The privilege only exists to communication that a patient makes for the purpose of diagnosis or treatment of a mental or emotional problem. For example, the privilege would not extend to someone who consults a therapist for career counseling. It also only applies to the substance of the communication, not that the communication took place. The Supreme Court recognized this federal psychotherapist-patient privilege in the 1996 case of Jaffe versus Redmond. In 1991, police officer Mary Lou Redmond responded to a report of a fight in progress. A few minutes after arrival, Officer Redmond shot and killed Ricky Allen Sr. Allen's family filed suit against Officer Redmond and the city, alleging that Redmond violated Allen's constitutional rights and caused his wrongful death. After the shooting, Redmond sought counseling from a licensed clinical social worker, eventually seeing her more than 50 times. At her deposition and throughout trial, Redmond refused to disclose information about what was said in the counseling sessions. The plaintiff subpoenaed the social worker for her notes and records on Redmond, but the social worker refused to admit them. At trial, the district judge instructed the jury that the defendants had no legal justification to refuse to produce the social worker's notes of her counseling sessions with Officer Redmond. Over objection, the district judge instructed the jury that it was entitled to presume that the contents of the notes would be unfavorable to Officer Redmond. When the case reached the Supreme Court, the court asked whether a privilege protecting confidential communications between a psychotherapist and her patient promotes sufficiently important interests to outweigh the need for probative evidence. The court determined that it does, establishing the federal privilege. Most states already recognized a psychotherapist-patient privilege, so the court easily agreed with the wisdom of state legislatures and the advisory council that originally proposed Rule 504. The court also rejected the use of a balancing test in deciding to admit the evidence or not. The court held that making the promise of confidentiality contingent upon a trial judge's later evaluation of the need for evidence would eviscerate the effectiveness of the privilege. But the court also recognized that Rule 501 left the question of privilege to the courts, and that all of the contours of the rule would not be fleshed out in just this one case. Now that we've established the federal privilege, Tommy's going to talk us through the exceptions of when that privilege does not apply.
Here we have laid out for you a brief summary of the exceptions that many federal courts have held to apply. One of the most important exceptions is the patient litigant exception. Under this exception, when a party bases a claim or defense on her mental or emotional condition, the privilege may be held not to apply. This exception is the most frequently invoked exception to the privilege in civil cases. And this was one of the exceptions addressed in rejected Federal Rules of Evidence 504 D3. Federal courts have interpreted both broad and narrow exceptions to this privilege. In Lanning versus Southeastern Pennsylvania Transportation Authority, the plaintiff's psychiatric records were compelled because they were seeking damages for injury to their emotional well-being. On the other hand, in Vanderbilt v. Town of Chilmark, the court held that the plaintiff must use the privileged communication as evidence herself before she waives the privilege. In criminal cases, this exception often arises when a defendant raises an insanity defense. In United States v. Sturman, the court held that until a defendant proceeds with an insanity defense at trial, he cannot be said to have waived his rights under the psychotherapist-patient privilege. Courts split on whether to interpret a dangerous patient exception. A non-federal court case in the Supreme Court of California, a well-known tort case, held that mental health professionals have a duty to protect individuals who are being threatened with bodily harm by a patient. This duty may include notifying the police, warning the intended victim, or taking other reasonable steps to protect the threatened individual. Although this was a state court case, it's been influential in helping many federal courts interpret the reasoning and existence of a dangerous patient exception. Notably, the Fifth Circuit has held that a tariff-off warning regarding a threat makes that threat admissible in subsequent criminal proceedings. Conversely, the court in US v. Gain made clear that the issuing of a tariff-off warning, even with the patient's explicit consent to the warning, does not waive the psychotherapist-patient privilege to the communication. In that case, the Eighth Circuit joined the Sixth and Ninth Circuits in declining to recognize this dangerous patient exception. Here are two miscellaneous exceptions that arise less frequently in litigation. The right to confront witnesses is embodied in the Sixth Amendment. When a party seeks to introduce medical records, that right collides with the psychotherapist-patient privilege. In United States v. Hayworth, the defendant sought to discover the records of psychotherapists who had examined a witness for the prosecution. The court held that the records were privileged under Jaffe, and that the defendant's constitutional right to confront the witnesses against them would permit cross-examination of the witness at trial, but not examination of the treating therapist's records. A leading case interpreting the crime-fraud exception is in re-grand jury proceedings, Gregory P. Violette. The court held that because of the similarities between attorney-client privilege and psychotherapist-patient privilege, a crime-fraud exception should be recognized. The court was careful, however, to limit the scope of this new exception. The crime-fraud exception will only apply in this circuit when the patient's purpose is to promote a particular crime or fraud. Simply talking about past crimes will not create an exception under the crime-fraud exception. Waiver of privilege is technically distinct from exceptions to privilege. It's more of a situation where the privilege simply doesn't attach. A party may waive the privilege by voluntarily disclosing a confidential communication to someone else. Despite this technical distinction, federal courts often describe the previously mentioned patient litigant exception as an implied waiver of the right. Under the broad view of waiver of privilege, some courts have held that this privilege is waived anytime someone puts their mental or emotional condition at issue in the trial. Under the narrow view, this privilege will only be waived if the privileged communication is at issue in the trial and the defendant and the party raising the privilege brings it up. Important when considering exceptions to any privilege, particularly psychotherapist-patient privilege, you must consider the policy considerations that created the privilege in the first place. Many legal scholars, knowing the reasoning in Jaffe, believe that when federal courts interpret broad exceptions to a privilege, It greatly harms or even destroys the public and private interests that the privilege was created to support. Namely, this is the fact that we want people to be able to feel comfortable in therapy, expressing their deepest secrets, telling the truth, and being able to get advice that will help them manage their symptoms and avoid dangerous acts. Now that we've talked about some of the federal exceptions to this privilege, Lyndall is going to walk us through how federal courts have applied psychotherapist patient privilege.
Florida Statute 9503 is what governs psychotherapist patient privilege in Florida. The term psychotherapist includes all persons that are certified or licensed to engage in the diagnosis of a mental or emotional condition, including alcoholism and other drug addiction. A patient under the statute is a person who consults or is interviewed by a psychotherapist for purposes of diagnosis or treatment of a mental or emotional condition, including alcoholism and drug addiction. The communications between a psychotherapist and a patient are generally privileged. The claim of privileged is assumed in the absence of evidence to the contrary. So who can claim privilege? Privilege may be claimed by a patient or the patient's attorney on the patient's behalf, a guardian or conservator of the patient, the personal representative of a deceased patient, the psychotherapist, but only on behalf of the patient. Once privilege is established, the next analysis is to determine whether any exceptions to the privilege rule apply. The statute lists 3 exceptions to privilege. The first exception is communications relevant to an issue in proceedings to compel hospitalization of a patient for mental illness. The statute requires that a patient be in imminent danger of hurting themselves or others, or in need of care but lacking the capacity to seek it themselves. The second exception is communications made in the course of a court-ordered examination of the mental or emotional condition of that patient. When a criminal defendant uses an insanity defense, the defendant must cooperate with the court in a mental and emotional examination, or the court will not allow any expert testimony on the question of insanity. In a criminal case, the evaluation and purpose of using that information obtained from one of these court examinations is not to determine guilt or innocence, but the presence or absence of mental illness. So in a criminal case, this prohibits the psychiatrist from testifying directly as to the facts surrounding the crime, where such facts have been elicited from the defendant during the course of one of these compulsory mental examinations. But if the defendant's counsel opens the inquiry to a collateral issue, admission or guilt, the state on redirect examination could inquire within the scope opened up. Third, privilege is waived under Florida Statute 9503 when a patient's mental or emotional condition is affirmatively placed at issue in pending litigation. The purpose of the waiver is to prevent a party from using the privilege as both a sword and a shield, and that the party can't seek to recover for emotional damage while simultaneously hiding behind that privilege. Privilege is waived when there's a specific allegation of mental anguish, but privilege is not waived when the claim is for loss of enjoyment of life without something more. While the psychotherapist patient privilege, like any privilege, can be expressly waived, waiver can be implied from any conduct or disclosure that is inconsistent with the maintenance of privilege. Generally, communications made in the presence of third parties whose presence is known to the defendant are not privileged from disclosure. It's very similar to attorney-client privilege in this sense that conversations are still confidential in the presence of a third party that is there to help the therapist with the treatment or diagnosis. Any failure to timely assert privilege will waive that privilege, and only once privilege is waived can the judge conduct an in-camera review of all the documents and communications. But this does not mean that all of those documents and communications are accessible. Any communications that are brought in or portions of those communications must still be relevant. Even though Florida doesn't have a formal balancing test as to what comes in and what doesn't after one of these in-camera reviews, the court is constantly balancing, to a certain degree, a person's interests and privacy rights versus the information that is necessary to ensure that justice is served. For example, it is a general rule under the statute that privilege is only waived if the party seeking privilege puts their mental or emotional condition at issue and not the opposing party. This makes sense. If this wasn't to be the rule, then an opposing party could always fall under the privilege exception by claiming that the other party was suffering from a mental or emotional condition, making it an issue in the case, and then thus making that person's past psychotherapy communications relevant. Florida courts have recently had to deal with the competing interests of upholding this general rule that bars the opposing parties from raising the other party's emotional or mental conditions with the opposing party's right to a fair trial. In a recent case, Traffenstead v. State, Traffenstead was found guilty of sexual battery upon a child, KT, who was between 12 to 18 years of age. Traffenstead appealed since he believed the victim's mental health assessment that had previously been done regarding a RAD diagnosis, which is a disorder known to cause irritability and fearfulness with caregivers, was relevant to his defense. Prior foster families described the victim's behavior as aligned with a RAD diagnosis, and that KT had violent outbursts and there were incidents of untruthfulness. Traff instead believed these facts are relevant to KT's credibility or bias, especially in the context of allegations of child sexual abuse, where KT was the only source of evidence from the state's case. The state argued that Florida's statutory psychotherapist patient privilege does not provide for the exception that Traff instead is requesting, and that defendants should not be able to get rid of this privilege without clear statutory authorization. The court vacated Traffenstedt's conviction and ordered a new trial, reasoning, the rules under this Florida statute do not abridge an accused's right to present a defense so long as they are not arbitrary or disproportionate to the purpose they are designed to serve. The court held that it is undeniable that strict adherence to procedural rules may give way to defendant's right to present relevant evidence in his defense. This court has made it clear that judges have a duty to admit evidence that does not fit neatly within the confines of the evidence code in order to protect the defendant's right to a fair trial. A defendant's Sixth Amendment rights to confront adverse witnesses may implicate this rule, but the court did agree with past courts' conclusions that disclosure of privileged records is required only under rare and compelling circumstances, and this case is such an occurrence. This is just one instance where courts are wrestling with the protection of people's privileged documents while also wanting to ensure everyone has a fair trial. Now I'm going to pass it off to Catherine, who is going to further talk about the other exceptions that fall outside of Florida's 9503.
There are also other exceptions to 90.503 that fall outside of 90.503 and are enumerated by a statute. The first being when a patient is involved in treatment with a psychiatrist and makes a threat of physical harm to an identifiable victim. This is similar to the exception seen under federal cases or as seen in the Tarasoff case. We know that this exception is waived in regard to making it known to police that there is a possible dangerous patient. But are these statements made by the dangerous patient waived in court too? The court in Guerriere held yes, and that to summarize, the psychotherapist patient privilege exists as a matter of public policy to promote the benefits of the full and frank disclosure of information between the psychotherapist and patient. The benefits are deemed by legislature to outweigh the cost of relevant probative evidence lost in the privilege. The balance shifts, however, when a patient communicates a threat that's likely to occur. Because communications do not create a net benefit to the public that warrants the application of the privilege, the rationale that underpins this privilege vanishes or at least diminishes significantly. The second is the abrogation of privileged communications in cases involving child abuse, abandonment, or neglect. This privilege shall not apply to any communication involving a perpetrator or alleged perpetrator in any situation involving a known or suspected child abuse, abandonment, or neglect. In Hill v. State, the court found that the psychotherapist patient privilege does not exist in this case as to any communications relevant to the child neglect felony count. But the privilege is not entirely waived just in relation to the statements made relevant to the issue of child neglect. The third is the abrogation of privilege, and the privileged communication does not apply to any situation involving a known or suspected abuse, neglect, or exploitation of a vulnerable adult. However, this statute does not only apply to a perpetrator, as seen in the last statute. Are these claims subject to due process? Or is this privilege subject to due process? Following Jaffe, several courts have found that this privilege is not subject to a separate balancing test that may let privilege in if a court finds there is a good enough reason, or subject to due process claims. Earlier Florida decisions found that it was subject to due process. However, the fourth DCA overturned its prior decision to allow due process to waive privilege. Accordingly, JB versus State followed that decision and stated that the privilege is not subject to a balancing test and that the due process protections do not entitle a defendant to pierce the privilege protections. However, defendants may often make very good arguments and also at the same time assert their Sixth Amendment rights. As seen in Traffenstead, the court did find a good enough reason to allow the defendant to pierce this privilege. So it's still up in the air between many jurisdictions, but a defendant may be able to make a good enough argument to either argue that due process or the Sixth Amendment right to confrontation allows a defendant to pierce that privilege. Additionally, there is no doctor-patient privilege or physician-patient privilege in Florida or under Jaffe. The psychotherapist-patient privilege is rooted in the imperative need for confidence and trust. Treatment by a physician for physical ailments can often proceed successfully on the basis of a physical examination, objective information supplied by the patient, and the results of diagnostic tests. Effective psychotherapy, by contrast, depends on an atmosphere of confidence and trust in which the patient is willing to make frank and complete disclosures. Florida has no statute recognizing physician-patient privilege, nor has such a privilege existed by common law. However, states such as Ohio have listed this privilege. If a doctor believes that certain statements are subject to privilege, they may request an in-camera review to see if these are about emotional issues. Finally, I will compare the federal exceptions and the Florida exceptions. Federal exceptions are more based upon case-by-case bases and differ widely between jurisdictions. The more common and recognized known ones are the patient litigant exception, the dangerous patient exception, possibly the crime fraud exception. However, Florida has a lot by statute, including communications relevant to an issue in proceedings to compel hospitalization, such as the Baker Act, communications made in the course of court-ordered examination, communications relevant to the mental or emotional condition if that patient places that at issue, possibly a due process waiver, but newer cases have held no. There is an exception under the Sixth Amendment under Traffenstead, and threats to an identifiable victim and child or neglect or elder abuse. And now I will pass it over to Karen to cover hearsay.
So far, we have discussed privilege and confidentiality between patients and their psychotherapists, and how patients may waive this privilege if these communications are brought up, for instance, at trial. You're probably asking yourself, aren't these outside the courtroom statements considered hearsay? Yes, these statements may be hearsay, but there is an exception under the Federal Rules of Evidence, Rule 8034, statements made for medical diagnosis or treatment. This rule was originally limited to statements made to physicians for physical injuries, but has been extended to allow the admission of statements made to psychiatrists, psychologists, and other practitioners of psychotherapy, such as social workers and counselors, for the diagnosis and treatment of mental health issues. This rule applies regardless of whether the declarant is available to testify or not. This means that the declarant is not under oath and is not subject to either cross-examination or to a jury's evaluation of demeanor. You might ask, then how can we be sure these statements are reliable? Well, although there's no guarantee that the statements are true, this hearsay exception assumes that the statement is more likely to be true than most other hearsay because the person seeking the medical help has a strong interest in reporting symptoms honestly and precisely in order to receive effective treatment. There are three scenarios in which these types of statements would be admitted at trial. The first is a typical case in which the psychotherapist testifies to statements made by the patient during a therapy session, and then that testimony is admitted to prove the truth of the matter asserted. The second is a statement made during medical treatment after a traumatic experience, such as a sexual assault. The third is a statement from which a psychotherapist examines a defendant for trial-related diagnosis, such as diminished capacity or the ability to stand trial, which are usually more rare. Now let's take a look at a case from Ohio that applied the exception. In State v. Curitin, the defendant was charged with felonious assault against his wife, Deborah. At trial, her psychologist testified that she shared with him previous instances of domestic violence, including pushing, grabbing, and hitting. As a result of this abuse, the psychologist diagnosed her with depression and anxiety. The court held that the testimony was admissible under the Federal Rules of Evidence, Rule 8034, because the statements regarding the abuse were necessary in order for the victim to receive proper psychological diagnosis. We now turn to the Florida statute's version of the hearsay exception, statements made for purposes of medical diagnosis or treatment. This statute also applies regardless of whether the declarant is available to testify or not. So now we are going to going to take a look at 2 Florida cases in which the hearsay exception was raised. The first case, Begley v. State, refused to apply the exception. In this case, the defendant was charged with committing a sexual battery on a child. A counselor at a sexual assault treatment center met with the child just to see how she was doing and what was troubling her at the time. The counselor testified at trial about statements made by the child regarding the sexual act. The counselor also testified that part of her job was to prepare young children for their courtroom testimony. The court held while the statements do not need to be made to a physician, there must be a showing that A, the statements were made for the purposes of diagnosis or treatment, and B, that the individual making the statements knew the statements were being made for this purpose. And in this case, the court ruled that the state failed to show how the statements were reasonably pertinent to any diagnosis or treatment. On the other hand, we have Williams v. State. In this case, the defendant was also charged with committing a sexual battery on a child. A social worker arranged for the child to be examined by a physician. The social worker testified at trial that the child told both her and the physician that the defendant committed a sexual act on her. The social worker also testified that her role was to ensure the child knows why he is at the medical exam and to obtain history so that the medical examiner can diagnose or treat. Since there is an attempt to diagnose an injury, the court made an express finding that the child knew his statements were being used for medical diagnosis and possible treatment. Here we have both the federal rule and state statutes side by side. As you can see, they are very similar to each other. However, the state statute is a bit more specific in the language. For example, the statements must be made by the person seeking the treatment or by a person who has knowledge of the facts and is legally responsible for the patient. This is usually parents of young children and family members involved in the treatment in the elderly. The federal rule does not make this limitation. Another difference that you might notice is the requirement that the individual making the statements knows that the statements are being made for these purposes, which was established by Begley v. State, which we reviewed on the previous slide. And as always, there's that pesky Rule 403 balancing test lurking in the background, which Florida courts also implement when deciding these types of cases. Thanks for listening.